Hi guys, welcome back to Battle with Ola. This is Mujela Alua and I'm super thrilled to be here once again. I just want to thank you all for all your warm comments on the channel so far. I was reading a comment this morning and I noticed that that particular video has 10,000 views, probably over that, but YouTube is showing me 10,000 views, several comments and almost 1,000 likes. And it just wowed me because, especially for likes, sometimes it goes unnoticed. But each time I notice a large or a high amount of likes on a particular video, it warms my heart that you would not just watch, but you would actually make a mental note and take an actual decision to like the video. So thank you so much. Today I want to talk about the order of Mandamus. The order of Mandamus. The order of Mandamus is a judicial remedy, so are certiorari and prohibition. We're going to talk about those in other videos, but this particular video is for Mandamus. What is Mandamus? Mandamus has its roots in Latin as a word or a concept, and it generally means we order. If I remember my Latin for lawyers very well, I know that it has its roots in mandao, a word called mandao or something close, which means we order. We order. That is, we command you to do something. So order of Mandamus, you notice that I said we have prohibition, we have certiorari. Prohibition would mean that we compel you not to do, that we prohibit you. We'll talk about that in another video, but this video is for Mandamus, which is we order, that is, we command you to do certain things. The order of Mandamus is an order that can be made by a superior court commanding a lower court to do something, or to make sure that they do not act ultra vires or ultra vires. It can also be made upon a public servant or a public official to command them, compel them to do something they are supposed to do, something within the bounds of the legal authority that they have. So the order of Mandamus is something that an applicant can come before the court to ask the court to make by taking out a writ of Mandamus. So filing the writ, you tell the court that, oh, this particular public official, they have the power to do this, they are supposed to do this in their line of duty, or the court is supposed to take this decision, maybe rule on this motion, and they have refused to do it for this length of time, and I'm entitled to this from them, and it has taken so long and I do not have another remedy. So you notice that I've highlighted some things. These are things that the court will consider before hearing you and issuing an order of Mandamus. There must be a public duty. The duty must be owed to an individual who will now be the applicant, taking out a writ of Mandamus. And then this duty must be one that the applicant has asked or demanded of that public official or that court, and which the public official or the court has refused to carry out. And there must be no other remedy that the applicant can explore, that would, effectively get them what they're looking for. And so they come before the court and ask the court to make an order of Mandamus. So if the court is satisfied that these conditions have been fulfilled or complied with, the court will make the order. For instance, if you have made an application before a government agency and maybe you require something from them, maybe you require a document or an approval from them, and there's a normal time frame within which your request should be acceded to, or your request should be approved and whatever you're asking for granted, and that the time has elapsed and you have not got what you want, and there's unreasonable delay, you can apply to the court, take out a writ of Mandamus asking the court to compel that government agency, that public department, to do what they are supposed to do in their line of duty. Now, you cannot abuse this order because it must be shown that they are supposed to do it for you or to you, and they have refused to do it. You have asked, you have placed a demand, and they have refused to meet that demand. It must also be clear that it is not a discretionary duty or function. For instance, if it's something that they have the discretion not to do within the bounds of law and what is reasonable and they have exercised that discretion accordingly, you cannot then come to court and ask the court to compel them to fetter their discretion. You cannot do that, except you can show that even though they have discretionary power to concede or to refuse me what I've asked, they have exercised this discretion out of malice or improperly or with an ulterior motive. So if you can prove that, the court will still grant the order of mandamus. It can also be taken out against a lower court. If a lower court, maybe you filed a motion that is very fundamental, maybe to some other cases, or that is a deciding factor, in the grand scheme of things, and the motion has stayed before the court has refused to rule on that motion, maybe for several months or even years, you can apply to a higher court, compelling the lower court to rule on the motion so that you can move forward with your matter or move forward with your life. So that's essentially what an order of mandamus is. You can check at the Baggs case. That's where you would find its roots in law. In that case, Baggs was the chief burgess of Plymouth and he was removed from office. And the order of mandamus was made to reinstate him because he was removed without fair hearing. So it's compelling the public authority that removed him to follow due process according to their schedule or line of duty and what they have powers to. If you check the Nigerian cases of Shitabe and Federal Public Service Commission, Fayemi and Akilu, these are cases that also explain the order of mandamus and the conditions that will warrant, the grant of the order or the refusal thereof. So it must be shown that there's a public duty owed to an individual by a public office or by the court, and that the duty has not been exercised or has not been exercised judiciously and fairly, or that there's been delay or refusal, outright refusal or delay to actually exercise that duty, and that there is no other alternative. Because if there's another alternative, the court will refuse the application and ask the applicant to explore other remedies available. So it's like a last resort. So it's not, a commonplace order that you see the court making every day and every other day. So it's a very serious matter. This is all I have for you on the order of mandamus. We'll talk about certiorari, prohibition, and several other things lined up on the channel. Please stay watching and bring a friend over to Battle with Ola. To-dos.